On April 30, 2026, the Ugandan High Court sentenced Christopher Onyum to death for the brutal murder of 4 toddlers at a daycare center in Gaba, a crime that shocked the nation. This commentary analyzes the legal foundations of that sentence, its practical implications, and the interplay between domestic law and the charged public atmosphere that preceded it. Under Uganda's constitution, the death penalty is legally permissible punishment. Article 22(1) explicitly protects the right to life but makes an exception for the execution of a sentence imposed by a competent court for a criminal offense. The method prescribed in law for carrying out this sentence is hanging. In the landmark 209 case, Attorney General versus Susan Chigula and 417 others, the Supreme Court of Uganda reaffirmed the constitutionality of the death penalty and, crucially, ruled that hanging does not constitute cruel, inhuman, or degrading treatment. Therefore, on paper, the sentence handed down is legally sound. Despite the legal clarity, the question of whether Okello will actually be executed is far more complex. Uganda is a de facto abolitionist state, having not carried out a single execution since 1999, even if for those on death row, a sentence effectively means life imprisonment unless the president signed a death warrant. Following the 2009 Chigula ruling, a death row prisoner who remains unexecuted for 3 years beyond their mandatory appeal process is entitled to have their sentence commuted to life imprisonment. These procedural realities make the ultimate enforcement of a death sentence exceptionally unlikely, transforming it into a largely symbolic act by the judiciary. This judicial outcome, however, did not unfold in a vacuum. On the day of the arrest, General Muhoozi, Uganda's Chief of Defense Forces (CDF), made a public pronouncement on social media. The suspect in the Gaba horrific attack against children has already been apprehended. We shall push for the death sentence for the criminal. This was echoed by fervent public sentiment, such as the statement from Lillian Aber, who posted, "Well done, CDF. The moment that monster touched our children in Gaba, he signed his own death warrant. No mercy, no excuses." The judge, Justice Alice Kamwenga Kakuka, explicitly stated that Okello's crimes met the threshold for the rarest of rare cases warranting capital punishment. In her sentencing, she cited the pre-planned nature of the attack and Okello's complete lack of remorse. While she provided a robust legal rationale, the pronouncements from a high-ranking military official before any judicial process had begun raised concerns, creating a perception that the court may have faced direct political pressure to deliver a predetermined outcome. The statement also puts Uganda at odds with a growing international consensus. The United Nations and Amnesty International consider the death penalty a violation of the right to life and the ultimate form of cruel, inhuman, and degrading punishment, consistently calling for its total abolition. A 2023 report from the UN Human Rights Committee explicitly urged Uganda to repeal laws prescribing capital punishment. Many nations, particularly in sub-Saharan Africa, are moving away from capital punishment. From the perspective, the sentence represents a regressive step that deepens Uganda's isolation from evolving human rights standards, even if it reflects domestic legal provisions and a local desire for retribution. Ultimately, the outcome is a deeply ambiguous one. On one hand, justice was served in its most basic sense. Christopher Onyum was given a fair trial, convicted based on overwhelming evidence, and sentenced to the maximum penalty permitted under Ugandan law for an exceptionally brutal and heinous crime that shattered a community. On the other hand, justice is a process, not just a verdict. The preemptive statement from Muhoozi, which signaled an executive branch demand for a specific judicial outcome, undoubtedly cast a long shadow over the proceedings. This created the inescapable perception that the scales of justice were tipped by political pressure. While the ultimate sentence is constitutionally valid, path to it was paved with pronouncements that challenge the fundamental principle of an independent judiciary. The sentence, therefore, is a complex mixture, a legally sound outcome for a horrific crime, and marred by the deeply problematic way in which it was publicly demanded and delivered.